All right, welcome to Social Psych and the Law video lecture for Wednesday, April 19th, 2017. So a quick note here, this lecture might go a little bit longer than our usual 55-minute class, but we're going to compensate for that because the last topic, interventions, for Friday is probably going to run a little bit short. All right. So today we're going to talk about four major things. We're going to talk about whether eyewitness testimony is reliable. We're going to talk about what do interrogation tactics really do. Can jurors ignore inadmissible evidence? And how well do lie detectors work? So social psych, as we've been talking about throughout the class, can provide really important insights into a lot of different domains in the real world, one of which is the law, which is why we're taking a day to talk about that specifically. So in this lecture, we're going to talk about different kinds of knowledge that we've talked about so far throughout the class, how we can kind of synthesize that to give us information and knowledge about the law in particular. All right, let's go ahead and start with whether eyewitness testimony is reliable. So usually when I teach this in actual face-to-face class, I start this class off with a quick 15-minute video about the case of Ronald Cotton, who went to jail for 11 years for a crime he did not commit. It's a really impactful story, and I've included a YouTube link here. I'm not going to play it right now because it's definitely going to put us over the 55-minute class period, but I'm going to strongly recommend that you take some time first to go watch that because that's something you can think about throughout the rest of the lecture. All right, so again, the YouTube link is here. It's also, I've made a separate page for it on Carmen under the Social Psych and the Law module, so you can go check that out. All right. So assuming that you've now watched that and you're up to date on that whole situation. So this is an example of a false conviction. And, you know, it begs the question of why did that happen? So here you can see this is the cover of a book written about this this whole case by Jennifer Thompson, who was the person who accused Ronald Cotton, and Ronald Cotton himself wrote this book as well. So you can see on the cover of this book here, Bobby Poole is on the left, Ronald Cotton is on the right. So you can see they sort of a little bit look similar, but we'll talk about a lot of things that contributed to this issue, different factors that led to Ronald Cotton's false conviction and 11-year imprisonment. And moreover, what can we learn from this story to prevent this from happening in the future? So remember, Jennifer Thompson was sure that Ronald Cotton was the rapist. And this kind of leads to the issue where eyewitnesses are imperfect, and yet we rely on them so heavily. So 75,000 eyewitnesses testify in cases every year. And what's more convincing than an eyewitness pointing a finger at the person who committed the crime? But memory processes can be affected at any stage. We talked a little bit about this already. So memory processes can be affected at the encoding stage, which is where you take information into memory, so you're seeing it happening, encoding it into your memory. Memory processes can be affected at the storage stage. This is where you're retaining the encoded information over time, storing it. And memory processes can be affected at the retrieval stage. So this is where you're recalling information that you've already stored. And it can be affected here as well. So remember, we talked about memory processes, including things like memory distortion, way back in social cognition, much more recently in stereotyping and prejudice, and a few other places as well. We talked about how memory is not just a recorder. You're not passively just taking a video of things that happen in your world, and that's what you remember later on. We don't play back memories exactly as they occurred. So as we'll talk about today, there are things that can affect our memory both at the stage where we're taking it into memory, where we're storing it over time, and when we're remembering it later. So a stage at which eyewitness testimony can be impacted by memory problems is when you're having encoding problems. So encoding problems is where you're taking it into memory, remember? Well, one important thing that can impact that is the fact that arousal really starts to focus our attention on central features of what's happening around us. So arousal just means physiological arousal of any kind. Witnesses often overlook other details when they're eyewitness to some kind of a crime. So your emotional state influences what you encode into your memory. You can think about what kind of emotions you might be experiencing when you're the victim of a crime, or even just when you're witnessing what happened. You're probably experiencing fear. Maybe you're also experiencing anger. But these are types of physiological arousal. This can have huge effects on encoding events into your memory. So one big example of this is this idea of weapon focus. So if there's a weapon present at a crime, especially if you're a victim, but also if you're just a witness, the presence of that weapon is really going to draw attention. So when you're witnessing or experiencing a crime, you're really looking at the weapon. You're not really focusing on the face of the person holding it. So it makes it a lot more difficult to identify the culprit if the only thing you were really looking at was the weapon. And you can think about this as being really a very adaptive process, that's where our attention goes, because that's really where the threat is in the situation. Obviously, the person holding the gun is the threat too, but the gun in the situation is the thing that might end your life or might injure you severely. So it makes sense that that's what we focus on, but it means that we pay less attention to things like who the person looks like who was holding the gun. We can also have issues with storage as well. So even after we've encoded memory, even if we had no problems there, we can have problems with storage over time. So one problem that we have is that our memory for faces and for events is really likely to fade over time. And in particular, leading or repeated questions can actually bias our memory. We'll talk about a study example of this in just a minute here. If you think back to that 15-minute video, Jennifer Thompson could only remember Ronald Cotton's face as her rapist, even though he wasn't. But that's all she could remember. She could never picture anyone else except him. So you can think of that as being that she practiced that memory until it was real. So memory for the actual face of her rapist might have faded over time, but she supplied the idea of Ronald Cotton's face, and that's what she could remember, even though that wasn't really what happened. So post-event information can affect memory storage. And for the second bullet point here of leading or repeated questions biasing memory, you can see examples of these all the time. So whenever people are asking questions of an eyewitness or a victim, things like, a leading question example would be like, were you at the bar on the night of November 20th versus where were you on the night of November 20th? That first question is more of a leading question. It might lead you to search your memory for evidence that the bar is where you were, versus that second question, much more open-ended. You might be less likely to think that you were at the bar if you really weren't. And a quick note here, kids are especially susceptible to leading questions. So asking a leading question to kids, they're especially likely to have issues with remembering the actual event after presented with a leading question. Now, a quick plug here. On the last couple of lectures of this class, I've been kind of highlighting psychologists who have impacted the field that we're talking about. And for this field of eyewitness testimony especially, but social psych and a lot more broadly, one psychologist who's had a big impact is Elizabeth Loftus. So she's done a ton of work on reconstructive memory and various other kinds of these effects in this area. She's written a lot of books on her findings. You can see in the picture here a couple, as well as the one I've highlighted here, Eyewitness Testimony. So the next study we're going to talk about is actually work that she did that really tells us a lot about how storage can be affected if you're an eyewitness or a victim of a crime. So a fantastic example of this is this car accident study. This is done by Elizabeth Loftus and colleague back in the 1970s. Really simple setup. What they did was they had participants watch a film of a car accident, so just a little movie clip of a car accident. And after the film ended, they were asked how fast the cars were going. So they're asked to give a miles per hour estimate of how fast the cars were going. But this is just the beginning of the question. There are 3 conditions in this study, and each condition is how that question was finished. So in the first condition, they were asked how fast were the cars going when they contacted. In the second condition, how fast were the cars going when they hit. And in the third condition, how fast were the cars going when they smashed. So you can see a really simple setup. They watch the same film of the accident. The only difference is how the question is framed. So the first condition here, when they contacted, is kind of the most just basic. When they hit, a little bit more, and then when they smashed, you can see there's a bit more of a suggestive word choice. Smashed indicates that maybe they're going really fast and they just rammed into each other. But again, that's the only difference between these conditions. You can see on the top here, this is kind of a picture representation of the study about how fast were they going when they whatever each other. And you can see with when they contacted each other, people on average gave an estimated miles per hour of about 30.8. When they hit each other, that jumps up to 34. And when they're asked how fast the cars were going when they smashed each other, that jumps all the way up to 40.8 miles per hour. So that's a 10 mile per hour difference. Again, they watch the exact same video. The only thing changing their estimates is whether the question is a leading question or not. So you can see on the bottom here, it's kind of like the original information versus how the question can bias your memory. But again, the mile per hour estimate is only differing based on the wording used in the question. So in this study and others as well, they also add a little bit of an extra thing where they ask, was there broken glass at the scene? So in reality, there was not. The video had no broken glass. But they ask, in each of the three conditions, they ask, was there any broken glass? And they find that participants are more likely to say, yes, there was broken glass when people are using the smashed wording versus the hit or the contacted wording. So questions and wording can bias our memory. And actually, memory storage is so malleable that you can even implant false memories. So here's Elizabeth Loftus again. This is about a 2-minute video where she is going to talk about implanting false memories. So let's go ahead and play it.
Can you go so far as to suggest an entire memory of something that never happened?
Chris is the subject of a false memory experiment. The Loftus researchers had several of his family members record in a journal some real events shared by the family. A false event, being lost in a shopping mall at the age of 5, was added to the journal, which Chris read and ultimately remembered as real.
I remember getting lost and I was crying, and I remember that day I was so scared I thought I'd never see my family again. I knew I was in real trouble. I remember in the stores, maybe I sort of remember the stores. An older man approached me. He was tall, and I don't know his age, but he was older. He had a flannel shirt on. I remember the flannel shirt. And I remember my mom told me never to do that again. And
Well, in terms of Chris's memory, there was no man, there was no flannel shirt, there was no mother who said, don't ever do this again.
Using deception in psychological research is a controversial but sometimes unavoidable practice. When the Loftus research team informed Chris that they had implanted a false memory, they followed a debriefing procedure designed to minimize any distress that participating in the study might have caused.
If there were 3 words that I would come up with to describe what memory is, I would say memory is suggestive, it's subjective, it's malleable.
All right, so that goes to show that beyond just biasing memories that you already have, you can even go so far as to plant a false memory. And you can think on your own about how that might impact eyewitness testimony, leading questions. And we're actually going to revisit this idea a little bit later in the talk when we get to false confessions. So does this make you nervous that somebody can make you remember something that never even happened? I mean, I'll tell you that in the studies on implanting false memories, there are always a reasonable number of people who don't buy it, who don't recall a false memory, and it's always possible that you might fall into that category, but you might just as easily fall into the category of people who will remember a false memory. All right, so keep that in mind as a thing that can impact eyewitness testimony. All right. Now, the last kind of memory problem that we're going to talk about with eyewitness testimony is retrieval problems. We've talked already about encoding and storage problems. Retrieval is when you are recalling past information that you've already encoded and stored, when you're remembering something again. And research shows that every time you retrieve a memory of any kind, not just limited to eyewitness testimony, but any time you retrieve a memory of any kind, it increases the risk of distortion. So retrieval, again, pulling information out of memory. In terms of eyewitnesses engage in retrieval multiple times. So they have to recall what happened when they're talking to the police right after the event. They have to recall what happened if they're being questioned by investigators or lawyers, if it's going to trial, right? Every time they recount the incident to their friends, they're retrieving it again. And every time they do that, it increases the risk of distortion. So if you remember when we talked in Stereotyping and Prejudice about that memory distortion study, showed that comic of the 2 people on the bus, the black man wearing a suit and the white man holding a straight razor. And across time, when participants are telling the story to other people who haven't seen it, it gets distorted because your own biases are coming into play. So one big thing that matters with retrieval problems with eyewitness testimony in particular is lineup procedures. So lineup procedures can actually interfere with retrieval, and it can actually hurt accuracy. So with a lineup, remember, this is where a eyewitness or a victim is shown a series of people who might have committed the crime, and they have to pick out, okay, that one is the one who did it. So as far as lineup construction goes, there are two kind of big ways that the law system, the judicial system, sets up lineups: sequential and simultaneous. And research shows that sequential lineups are actually a lot better than simultaneous for a very important reason. It's because people are making absolute rather than relative judgments. So a simultaneous lineup presentation of people is just like in the image you see on the slide here. You have a bunch of people who are all in front of the eyewitness or the victim at the same time, and they're asked, all right, is one of these people the person who committed that crime? The issue with simultaneous presentation like this is that people are more likely to make relative judgments. So they're looking at persons 1, 2, 3, 4, and 5, and they're saying, oh, it's definitely not number 2. I think number 3 looks more like that person than number 4 did. So they're comparing them to each other versus just making an absolute judgment. So the alternative is a sequential presentation where instead of all 5 people here at once, you see one person at a time. So for each person, you decide, is this them? No, it isn't. Here's the next person. Is this them? No, it isn't. Versus, is this them? Yes, it is. So instead of comparing people to each other, you're making an absolute judgment. You're less likely to choose the wrong person with that kind of a sequential setup. And actually, the best lineup possible is what's called a double-blind sequential presentation. So sequential, one person at a time. Double-blind means the person who is facilitating the lineup, so a police officer or whatever, doesn't know whether the suspect is even there, doesn't know who the suspect is, so they have no way of unintentionally influencing the eyewitness's decision. And the eyewitness doesn't know either. So it's stressed that the actual person might not actually be in the lineup. So in that case, you're less likely to choose someone because you just feel like you have to choose someone. All right. So here I have another quick little video, about 3 minutes long, about these issues with lineup construction. So go ahead and play that.
Before the break, we asked you to join us in taking a test. We showed you a crime in progress and asked you to help us catch the thief. And we did it because today scientists who work with courts and the police declared there is a way for us to become better witnesses and help solve a crime. GMA News anchor Josh Elliott gives you the challenge.
Number 3, step forward.
It's been the staple of Hollywood crime thrillers for decades. The lineup, a criminal sampler platter of the guilty and the innocent, and a crime-fighting tool seen as increasingly unreliable. It all stems from an idea that is central to the very notion of criminal justice: the eyewitness account, something we've learned is far less reliable than we'd once thought. Put another way, if a crime's committed right now, right before your very eyes, just how much do you think you could tell us about the person who committed it? Not a lot, according to new research. In fact, one new study found that eyewitnesses participating in the conventional or simultaneous lineup picked an innocent member of the group 18% of the time, almost once in every 5 attempts.
Assuming that he's probably there somewhere, that whoever looks most like him must be him, and that's a problematic assumption.
Psychologist Gary Wells devised a study that involved witnesses to a man planting a bomb and then fleeing. He compared the results of simultaneous lineups with a newer method, sequential lineups. Eyewitnesses view portraits of one person at a time, not all at once. The study showed sequential lineups resulted in an innocent person being selected just 12% of the time, an improvement of 1/3. Such is the pain of Jennifer Thompson. In 1984, she falsely identified a man named Ronald Cotton as the man who'd raped her. He would serve 11 years in prison before DNA evidence later freed him, a reality she finds almost too painful to bear.
It was like ripping open, long-healed scars and hemorrhaging. I mean, it was awful.
The main thing to keep in mind is that the correct answer in a lineup may be none of the above.
So, let's go back to our person-snatcher. We placed him in a lineup of our very own with 4 other guys. So take a look, a close look. Right. Whom do you think it was? If you said it was this guy, you were right. And if you didn't, well, you see the problem.
So are they going to start this new way? What's going to happen? Which is
Very
better?
interesting. Law enforcement agencies do say increasingly that they would like to. One important note, though, neither method has shown to be superior in eyewitnesses positively IDing guilty parties. In fact, Diane, it happens roughly 25% of the time in both. It's really more about keeping innocent people out of prison.
Well, that's big. Okay, thank you, Josh. And coming up.
All right, so you can see that the number of innocent people who are chosen in sequential versus simultaneous lineups, it only drops from 18 to 12%. So that still means that innocent people are still being selected. So it's not a perfect solution to this issue, but it's better. So you can, as you saw in the video, of course, you can clearly link this to Ronald Cotton, this issue with Jennifer Thompson. In the video, the 15-minute video from earlier, she studied those pictures. You heard her talking about she was trying to make sure she got it right. She was studying them, trying to memorize them. And that might sound at face level to be a good idea, but really it's not. It should be a gut level decision of yes, this is the person who did it, or no. The longer you study them, especially in a simultaneous lineup, the more likely you are to be comparing them to each other, to be kind of talking yourself into the idea that this was the person who actually did it. All right. So another really important factor that affects retrieval is this issue of a cross-race effect, sometimes also called race identification bias. So the cross-race effect, this is the fact, the phenomenon, that it's easier to recognize and differentiate faces of your own race compared to of people of other races. So as applied to eyewitnesses, people have trouble identifying members of other races. This, of course, also clearly contributed to Ronald Cotton's false conviction, false identification. Why does this happen? Well, it's related to this in-group, out-group idea, specifically groups according to race. So the less contact you have with people of other races, the more this affects you because they're not part of your in-group. So if you are white, then you have an easier time recognizing and differentiating faces of other white people versus people of other races. If you're Asian, you have easier time identifying people of Asian descent versus other races, etc., etc. So again, this is largely because of context. So studies have shown that the more contact you have with people of other races, the more interaction you have with those people, the less this affects you. And this is also known to impact things like age. So it's easier to recognize and differentiate faces of people who are your own age versus, for example, people who are in their 80s and 90s. But studies show that this does not affect gender. You might be like, oh, I wonder why that is. It's because of contact. So gender contact is pretty unavoidable. It's much more difficult to segregate into gender groups now than it has been in the past. So we interact with people of different genders all the time. So there is no such thing as a cross-gender effect because we do have a lot of that contact already. All right, regardless of whether their memories might be distorted, though, there's one more important thing about eyewitness testimony to keep in mind. This is the idea of eyewitness confidence. So eyewitness confidence does not actually signal accuracy, but you might think that it does, right? Because if somebody is very, very confident that that was the person who did it, you might be like, oh, they really know what they're talking about. But it's not necessarily the case. So accuracy almost never matches the level of confidence. But confidence is very persuasive to judges and juries. So judges and juries usually don't know this kind of stuff, so they're much more likely to be persuaded by a very confident eyewitness, even though somebody who's very, very confident is not more or less likely to be correct than someone who is not very confident. All right, so that's our discussion of eyewitness testimony. Now let's move on and talk a little bit about what interrogation tactics really do. So, would an innocent person confess to a crime? You might think, well, no, of course they wouldn't. Why would they ever do that? But false confessions are actually more common than you might think. You can think about recent trends in the last, 5-10 years or so, of people who are being exonerated with DNA evidence even after they actually confess to a crime. So it is true that innocent people do confess, but why? There might be something about the interrogation. So police use tactics that are designed to get confessions, which is usually a good thing when your suspect is actually guilty, but this can really harmfully backfire if your suspect is actually innocent. So one interrogation tactic we can talk about is just as simple as the setting. So when an interrogation is going on, usually put the suspect in a small, soundproof room, and you don't give them a lot of contact with the outside, kind of put them in there by themselves for a while. They create this sense of isolation and helplessness. So it creates these feelings of aloneness and not being able to predict what's going to happen. It's not a very comfortable setting. And this is usually designed to, kind of make people freak out a little bit, which again can be good if you have a suspect who's guilty, not so good if your suspect is actually innocent. Another interrogation, or rather two interrogation tactics that are used to up the chances of getting a confession are good cop tactics and bad cop tactics. So good cop tactics, we usually call these friendly tactics. These are tactics where what you're doing is befriending the suspect and offering sympathy. The goal with this is to lull that suspect into a false sense of security. So playing the good cop, you're doing things like offering the suspect sympathy, like I understand why you might have done this bad thing, I totally get it. You're minimizing the offense or the crime, like, oh, it's not that big of a deal, anyone would have done that. Really, you're trying to lull them into a false sense of security so that they confess to you. Another topic very related is pressure tactics, or the bad cop tactic. So this is where what you do is you express certainty in the suspect's guilt. So you're claiming to have strong evidence that they're guilty. You're just bombarding them with these accusations, like, we know you did it, you absolutely did it, don't lie. The more you do this, the more the suspect feels unable to resist. So again, if you're a guilty suspect, this is good. You're going to feel like there's no way to get out of it. They definitely know you did it. You might as well confess. But if you're actually innocent, this kind of strong certainty that you actually did it can really make you start questioning to yourself whether you didn't actually do it after all. So this here is kind of like a typical script, an example of a script using 9 steps of interrogations. You might start by confronting the suspect with assertions of their guilt, developing themes that seem to justify or excuse the crime, interrupting all statements of innocence and denial. So every time they try to say, no, I didn't do it, you interrupt them like, yes, of course you did, don't lie. Overcoming all of the suspect's objections to the charges, right? These are kind of things like those more pressure tactics. You're keeping the increasingly passive suspect from tuning out, so trying to get them to not just sit there and ignore you. Then you might switch to more of a good cop tactic, so showing sympathy and understanding, urging the suspect to tell you everything. You could even offer them a face-saving explanation for the action, like, it's totally understandable why you did this. You did it because of this and this. Get the suspect to recount the details of the crime and then convert that into a full written confession. So now you might be wondering, okay, but isn't some of this illegal, these different kinds of tactics? It is illegal to make explicit false promises, so it's illegal to promise things like leniency or clemency if you're not actually going to do it. That's illegal. But it is legal to subtly imply lenience for confession. So as long as you're not making an explicit promise, you can subtly imply that confessing will get them off easier than not confessing. That's legal. And it's also legal to pretend to have incriminating evidence. So you think back to that bad cop tactic where you're just asserting that they're guilty and you have hard evidence that shows it. That's not illegal even if you don't have any evidence at all. So you can see how this can really backfire for a suspect who's really innocent, thinking that they have some kind of incriminating evidence and there's nothing they can do about it. This is how interrogation works. They make you think they have the dirt on you and they can get you off easy. Again, if you really are guilty, this makes it sound futile to deny it and easy to mitigate your sentence. So it seems like a good deal to confess. But even if you're innocent, this assortment of tactics can get you to confess to something you didn't do. Okay, so now you might ask, all right, but doesn't being innocent help? If you're innocent, shouldn't you not cave to these? The answer to that is not necessarily. And that's because people who are innocent suspects, actually receive the most pressure. That's because if you're an innocent suspect, of course they don't really have a lot of physical evidence on you because in reality you didn't commit the crime. They think you did, so they know that without physical evidence, they have to get a confession. So they'll use those tactics we were just talking about to even greater degrees. So confession is what they need in order to convict. And it's compounded by the fact that innocent people tend to waive their rights. So there's about 81% of innocent people waive their rights versus 35% of guilty people. That's because people believe that innocence will set them free. Like, I have nothing to hide, I can waive my rights, that's fine. But that's actually a really bad idea because it opens the door to these really strong pressure tactics, again, because you have less evidence if the suspect it really turns out to be innocent, so you really pile on the pressure. So people want to escape that interrogation situation. It's a really horrible situation to be in. So this can lead to false confession. So that pressure can lead to compliance, and not just confession, but really you didn't do it. It can even lead to you internalizing the accusations. You might actually start to believe that you did it, especially if you don't have a clear memory of the events, or again with presentation of false evidence against you. So you might actually start to internalize that accusation that you really did commit that robbery, you really did, do something while you were maybe mildly intoxicated that was illegal. And so we can talk about factors that contribute to this, things like memory and false evidence. So these kind of leading questions in conjunction with really strong pressure can actually lead to a bias in your memory where you might start to remember actually doing it. And again, false evidence as well. All right, but of course we don't just, these facts I'm telling you about don't just stem from nowhere. They stem from actual research studies that indicate that these things are happening. So one study that shows how interrogation, these kinds of tactics that they use can produce false confessions. So in the late 90s here, actually done with computers. This is kind of a complicated methodology, but what they did was they had participants type letters either quickly or slowly. So that's their first independent variable here. They're typing letters quickly or slowly on a computer, and they're told, this is very important, they're told do not hit the Alt key. So they're given clear instructions to not hit the Alt key. The computer then crashes after 45 seconds of this task, and they're asked, did you hit the Alt key? So did you cause that crash by hitting the Alt key? Everybody says no, they didn't. So a quick note here, this manipulation of typing quickly or slowly. If you're typing slowly, you have time to really look at what you're doing. You're like, okay, I definitely didn't hit the Alt key. I wasn't anywhere near there. But if you're typing more quickly, that tends to lead to worse memory. You're doing it more quickly. You're feeling maybe a little bit of time pressure. You might have a less clear recollection of whether you actually did hit that Alt key or not. But again, when they're told don't hit the Alt key, it crashes. They're asked, did you hit it? Everyone says, no, I did not hit it. The second part of this study then is what happens after that. So at this point, we introduce the second independent variable, which is a confederate. So the confederate in one condition says that they saw you press the Alt key, or there's no accusation. So in one condition, they have a confederate serve as kind of a witness. They lie. They say, yes, I saw you hit that Alt key. I was looking and you hit it, or not. So this is like having evidence. So again, this isn't really true. Nobody actually hit the Alt key. But this confederate is acting as a piece of strong evidence that you did. There are two DVs here then. One is about confession. So is the participant going to have confessed to the crime? Remember, nobody confessed before the introduction of this. The other dependent variable is going to be internalization. So what will the participant say afterward? Will they report that they actually did do it, that they really think that they did? Or will they be like, yeah, I confessed, but I didn't really do it? All right, so here are the results, part one. This is the confession DV. So you can see the control condition here is people who are not confronted with the false witness. The blue bars are the slow typing condition. The red bars are the fast typing condition. And on the right here, you see the condition where there is a confederate who says, yeah, I totally saw you do it. So when the situation is more ambiguous, typing fast versus typing slow, participants are more likely to confess in general, regardless of the conditions on the x-axis here. So again, that's because fast typing can lead to more issues with memory, recollecting what you actually did. But the big important thing here is that they're also more likely to confess when there is a false witness. And that's these two conditions on the x-axis here. So regardless of slow or fast typing, your likelihood of confessing jumps up a lot if somebody says, I saw you do it. And especially I want to point out this red bar for false witness and fast typing here. You can see that on the Y-axis is the percent who confessed. This red bar, false witness fast typing, that's at 100%. So 100% of participants who were typing fast, were confronted with a false witness, confessed to doing it. This is the second DV, this is the internalization DV. When you're asked afterward, did you internalize that? Like, do you actually believe that you did it? So for the control condition, you can see you can't even see the blue bar here, and that is the slow typing condition because nobody actually internalized it. So this is like a study. You're not really being convicted of a crime, so you're more likely to confess. You're like, okay, sure, I hit the Alt key. This DV is like, okay, but did you really believe that? So for that slow typing control condition, no one does. For the fast typing control condition, about 10% of people believe they did it, but 90% don't. But if you jump over to the false witness bars here with slow or fast typing, that's 40 and a little over 60% respectively of people who internalized that accusation. They believe the witness. Like, if that guy saw me do it, I guess I must have done it. And actually, about a third of the people in that fast typing false witness condition went even further when they were asked by the experimenters. They recalled false details about hitting the Alt key. So they said things like, yeah, I remember that my fingers slipped while I was doing that typing. So going further even than just internalize it, kind of like creating that false memory of having actually done it. All right, okay, but what about jury awareness of the likelihood of a false confession? If people know that a false confession is possible, will they take that into account and adjust whether they think someone actually did it? So in this study done in the 70s, was done as this kind of mock jury study. So the participants' jobs were to read about a murder case with no confession, in one condition, I should say. There's three conditions I'll show you about. In each condition, they're all reading about a murder case. In this first condition, there's no confession at all. There's just all different kinds of evidence. Without a confession at all, 19% of people voted guilty. All right, so that indicates that it's not like a clear-cut case. It's a little bit ambiguous. Not too many people voted guilty. If you give the same murder case details, but add a low-pressure confession, so it's like the person just came into the station and said, yeah, you got me, I did it. So it's clear that they weren't pressured into confessing. Then actually that jumps up to about 62% people voting guilty. The key condition here is if you add a high-pressure confession instead of a low-pressure confession. So people know that the high-pressure confession meant that it likely had been coerced, that it was under those difficult situation tactics we were talking about earlier, and they're explicitly told this, was a high-pressure confession, it might be false. They said that the probably coerced confession did not affect their judgment, that they were really just looking at the physical evidence of the case, but 50% of them still voted guilty. So clearly it did. So if they're told about a high-pressure confession and they're like, okay, but it might have been false, right? Then if it's really not affecting their judgments, then it really should drop back down to that 19% who voted guilty with no confession. But you can see there's still a huge jump up from that with 50% voting guilty, even if they knew that it might have been coerced. So even if juries are aware of the possibility of false confessions, they don't really discount it that much. All right, one more little study here before I move on. Maybe the issue is just that we think we can tell when people are lying in their confessions versus not lying. Maybe it's especially the case that police officers who are interrogating suspects think that they can tell a false confession from a true one. So a study that was done to look at this, done in, again, the late 90s, where they had actors commit a crime or not, and then they are interrogated. So they're motivated to appear innocent. So they videotaped these interrogations where the person who is being interrogated either really did commit this supposed crime or did not actually submit the crime. So people are watching the interrogation videos. The independent variable here is that half of the participants who are watching the videos were trained in deception cues, so cues that should help them identify when people are lying or when they are not. Half of them are trained to do that, and half of them are not. The DV is, can people pick out the guilty person versus the innocent person? So again, a series of actors who have committed crimes or not and are interrogated. So some of them are guilty and some of them are innocent. So people are watching those videos, they're trained to recognize deception cues or not. Can they effectively pick out people who are innocent versus people who are? So I'm going to show you the bars in the second here of the results. You can see on the left side we have a confidence variable DV, and on the right side we have an accuracy DV. The green bars are going to be the naive versus the pink bars are the trained. So pink bars are people who are trained in those deception cues, the green bars are people who are not. So as far as confidence in whether they can pick out that person who is guilty versus not, you can see a big jump from naive to trained. So people who are trained in those deception cues are like, oh yeah, I can totally pick out people when they're lying, more so than people who are who did not receive that training. But if you look over at their actual accuracy, you can see that that's really not reflected in their real accuracy. So 50 on this y-axis for accuracy is chance. So if we can't really reliably tell people who are lying versus people who are not, then we should be about 50-50 to choose lying or not. And you can see that both the green and the pink bars are hovering right around 50-50. They're actually statistically not significantly different than chance of 50%, basically just guessing. And if you look at the pink versus the green bars, there's actually a trend for people who were trained to be slightly worse. Don't want to put a whole lot of stock in that because it's not significantly different than 50%, but it's possible that they're even slightly worse. So even though these people who received that training are a lot more confident that they can pick out those people, they're not doing better than average. This data was with college students. They've also replicated this kind of study with real police detectives, the same kind of setup with receiving that training or not. And they have found that real police detectives are no better than these participants. So they're also not significantly better than chance at determining true confessions versus false confessions. So, of course, the question is why? Well, it's because people often are paying attention to nonverbal cues to determine whether they think someone is guilty. So are they twitching a lot? Are they fidgeting a lot? Are they not making eye contact? You usually might think of those things as indicative of guilt, but they can just as easily be indicative of anxiety. If you really didn't do it and you're afraid that they think that you did, you're just as likely to fidget and not make eye contact. So observers pick up on those anxiety cues and think that they indicate guilt when really they might not. And actually, only one group of people can detect lies at better than chance rates. Any guesses about who that group is? It's Secret Service agents. So Secret Service agents get some kind of extra special training to actually do better than chance at guessing when people are lying or not. All right, so that was all about interrogation tactics. And next we're going to talk just a little bit here about whether jurors can ignore inadmissible evidence. So when evidence is ruled inadmissible in a court setting, so inadmissible evidence can't be presented to the jury or a decision maker because maybe it was improperly obtained, it is prejudicial, it's hearsay, it's irrelevant, etc. The judge might then instruct the jury to disregard that evidence that was presented. But the question is, if that's the case, if they're instructed to disregard it, the evidence is ruled inadmissible, can you really get people to completely ignore it? Can you really strike something from people's minds or not? So one study investigated this, looking at inadmissible evidence. What they did was they had participants read about a murder case with weak evidence. So the participants are acting as a jury in this case. Well, they're not making a real decision to send someone, to jail or not, but they're reading about this case with weak evidence. In a condition where that's all they do is they just read that weak evidence, you get a whopping 0% of people voting the defendant guilty. So that's how weak the evidence is. But if there's just weak evidence here, nobody votes guilty. But in two other conditions, they hear a phone conversation that implies guilt. So in both of these other conditions, they hear about a phone conversation where the suspect is on the phone to somebody else and says, "I finally got the money to pay you off." So the phone conversation implies guilt. In one of these two conditions, the evidence is ruled admissible. So it's ruled, all right, you can pay attention to that, take that into account. Versus in the other condition, that evidence is ruled inadmissible. They're like, no, strike that from the record. Don't take that into account when you're making your decision. It was, it was illegally obtained or prejudicial, yada, yada, yada. So the question then is, how do people vote, what proportion of people vote guilty in that situation when they've heard that evidence implying guilt, but it's ruled not admissible? So this is going to show you the DV of percent of people who are ruling guilty, and the green bar is going to be that no tape condition. The pink bar is going to be when the tape is allowed, so that phone call is allowed as evidence, and the yellow bar is going to be when that tape is not allowed, so when it's ruled inadmissible. So in the condition that we already talked about, where there's no tape at all, just that weak evidence, we already talked about how 0% of people voted that guilty, so super weak evidence. When they hear the tape and it's allowed, that jumps up to 26% ruling guilty. So taking that into account, they're thinking, oh yeah, it's probably, it's a little bit more likely that this person really is guilty. In the yellow bar is going to show you when that tape is ruled inadmissible. So if people are really striking it from their minds, this should drop back down to 0. But it's not. It gets even higher. So that jumps all the way up to 35%. So if evidence is ruled inadmissible, it ends up being used in decision-making even more than when it is admissible. And that's even though the jurors said that the tape did not affect them, clearly it did. So can you strike evidence from people's minds? No, you can't. People will still take it into account. But why does this happen? We're going to talk about a couple of reasons why. The instruction to disregard that testimony can draw even more attention to that piece of evidence. So people are paying even more attention to that evidence, even though it's been stricken from the record and from they're not supposed to use it in their judgments. Partly that's because it's hard to ignore relevant information. If you think back to our couple of different discussions about thought suppression, so it's really hard to ignore information. So if somebody tells you don't pay attention to that, don't think about that, then it's really, really hard to do. It's very easy to backfire. And this instruction to not pay attention to that evidence might even go further and actually induce reactance. So we talked about reactance before, about if somebody says, oh, don't do that, you might feel reactance if you're like, oh, excuse me, I'm going to do that, just because you told me not to. So this, don't pay attention to that evidence that's inadmissible, might also induce some reactance. And this all, goes back to the idea that people are motivated to be accurate jury members. When people are on a jury, they usually know, that the person whose case they're hearing, their fate is kind of in their hands, especially with a more high profile, like a high violence crime. But even with these more minor crimes where you might have some jail time, that has a huge effect on people. So people are usually motivated to be accurate jury members, and it's really, really hard to ignore relevant information. So can you really rule something inadmissible and have people not pay attention to it? No. All right, we're going to wrap up today with talking a little bit about lie detector tests. So lie detector tests, also called polygraphs, these are machines that you get hooked up to and ask questions, and what the machine is doing is it's recording your physiological arousal. So it's measuring things like your pulse rate, your blood pressure, your breathing, how much you're sweating. So it's recording your physiological arousal. What people do is they hook you up to the machine and they start out by asking some baseline control questions. So you ask for known truths, so things like what's your name, where were you born, what's your occupation, how many how many kids do you have, or whatever. So these are questions that you answer truthfully, so you get a baseline level of physiological arousal, and then you move on to asking crime-relevant questions, like what were you doing on the night of September 5th? Have you ever met this person before? Did you commit this crime? And again, it's monitoring your physiological arousal. The idea here is that lying should increase levels of arousal and anxiety. So if you're lying, you're trying to cover up the truth, you should see corresponding spikes in your physiological arousal. So you should be able to determine when people are lying based on when those spikes are happening. But maybe you can already see a problem with this. aren't there reasons why you might have some physiological arousal even if you're innocent? I mean, it's scary to be considered a suspect for a crime. If they hook you up to this lie detector machine, they're like, we're going to find out the truth, and they ask you questions about the crime, you might have anxiety that has nothing to do with the fact whether you're lying or not. Even if you're telling the truth, you might still feel anxious because you're afraid that it's going to look like you're lying, and that might then create these spikes in anxiety and make them think that you actually are lying. So there's been a lot of controversy over whether polygraphs are legit and should really be used. So one study that looks at the accuracy of a polygraph machine took guilty suspects and innocent suspects, and they gave them the polygraph. They found that 98% of guilty suspects failed the test, so it indicated that they were lying. That's pretty good. That's what we would want to see, right? That when people are lying, it catches them. But the issue is when you look at the innocent suspects. You can see that 45% of innocent suspects also failed the test. And these are people who really didn't do it, but almost half of them failed the test anyway. That's a problem because then that can be used in, a court hearing or whatever as indicative of the person's guilt, when really it wasn't guilt at all, it was just anxiety. So that's obviously a huge problem where innocent people can look like they're guilty when really they're not. It also raises the issue of the fact that it might be possible to fake responses. So even if you really are guilty, you can still pass the test. So the key with faking responses is to increase your arousal on the control questions so that when you get asked the crime-relevant questions, it looks no different, it looks like you're not lying. So if you can increase your arousal in those control conditions, then you can get off scot-free. Another issue with these faking responses, not even faking responses, but if you really aren't experiencing those physiological spikes when you're lying, they can also make it look like you're not. So if you think about psychopaths, we saw a little bit about psychopaths in that altruism TED Talk video we watched in Helping Behavior. So research has shown that psychopaths have smaller than average amygdalas, and they really are not experiencing a lot of the kind of ups and downs, surges in physiological activity that most people do, which you can think about as being a reason why psychopaths might be more likely to hurt people and even to murder people, because they are not experiencing those surges in emotion in everyday life, so they have to do really extreme things to do that. So if that's the kind of person that you have hooked up to a polygraph test, when they're lying, they might not have any spikes at all, and they might look like they're telling the truth. So polygraphs really not doing what they say they're doing. They're not really detecting lies. They're detecting anxiety and arousal instead, and that might work, but it also might really backfire. All right, so that's the bulk of what we're talking about today with social psych and the law. So this here is where your video response So for part 1 of the video response, I'd like you to write a paragraph explaining what things you should keep in mind if you're ever the victim of a crime or witness a crime. So if you are ever an eyewitness, for example, what kind of things do you need to keep in mind based on what we've talked about today? Then write another paragraph about what you should keep in mind if you're ever a suspect in a crime investigation. You can write this from the perspective probably of an innocent suspect. You could do it as a guilty suspect if you want. But if you're ever a suspect in an investigation, what do you need to keep in mind about what people are likely to do and how that might affect you? In part 2, write one more paragraph identifying which concept from today's lecture you found most interesting and why. Alright, so remember you can write these 3 paragraphs from part 1 and part 2. You can write them on a single Word document, upload it to the Carmen Dropbox by 11:59 p.m. on Wednesday night. Let me know if you have any questions. And otherwise, we'll just wrap up with a little recap. So eyewitness testimony, as we've talked about, is highly unreliable and can be really subject to cognitive biases. Even though we rely on it so heavily in the justice system, there are a lot of problems with it. Interrogation techniques and lie detector tests can make innocent people look guilty even if they're really not. Inadmissible evidence can still affect jurors even if you try to get them to not pay attention. And last but not least, of course, polygraphs don't necessarily detect lies at all. So if you're interested in criminal justice at all, you probably learn a lot more about this kind of thing in your class. But it goes to show that social psychology, with all of our research on things like memory processes, stereotyping and prejudice with the cross-race effect, things like that, attentional processes with the weapon focus, has a lot to say about the justice system as it is and how we can work toward making it better so that we imprison fewer innocent people and perhaps we get better at identifying guilty people. All right, so that's it for today. Looks like we're right under the 55-minute class period time limit. That's, of course, excluding the 15-minute video on Ronald Cotton. If you decided not to watch that, really recommend that you go back and watch that because it's really interesting, really real-life consequences of these kinds of things leading to this, 11-year imprisonment that really should never have happened in the first place. And we can talk about all the factors, probably not all of them. We can talk about a lot of the factors that might have gone into that and why we really need to fix that so that that doesn't happen to other people again in the future. All right, thanks. The real-world interventions lecture for Friday is going to be under the Carmen module called real-world interventions. So go ahead and hop on over there and watch that. And have a good rest of your day.